I'm Brittany Lewis with Forbes Breaking News. Senator Mazie Hirono on Tuesday called it, quote, stunning that abortion rights are under threat. Blaming, quote, radical right-wing justices, the Hawaii senator issued an emphatic denunciation of a leaked decision by Justice Samuel Alito. The decision would strike down Roe v. Wade, which would remove federal abortion rights. Hirono also pushed for a Supreme Court code of conduct and discussed the proposition with witnesses. Let's take a listen.
Is being characterized as the stunning thing that's happening. Well, you know what? I should think that we should be so much more stunned by the fact that the radical right-wing justices on the Supreme Court are prepared to eliminate a constitutional right that the women in this country have relied on for almost 50 years. That is the stunning thing, and what the aftermath of that kind of a ruling is going to be for women and their families all across our country. That is the stunning thing that the Supreme Court, radical Supreme Court justices are doing. And then I ask, what's next, Mr. Chairman? Because we know that Justices Thomas and Alito have already signaled their desire to revisit Obergefell, which is the Marriage Equality Act. As far as I'm concerned, anybody in this country who cares about our civil rights and indeed our constitutional rights should be very, very concerned about what this court is prepared to do, at least the radical right justices of this court. Regarding this hearing, Mr. Chairman, I have a question for Professor Frost. The Supreme Court has existed for more than 20 years without an official code of conduct. However, in recent years, there seems to be an increasing need for such a code. Is there any reason why the Supreme Court should be excluded from a code of conduct?
No, I think not. And I think they needlessly damage their own reputation by being the only 9 justices out of the entire federal judiciary who are not subject to a code of conduct. At times, they say they follow the code of conduct for lower federal court justices. But I think we all know that it's one thing to say, well, I might follow a law I don't think applies to me or I know doesn't apply to me, versus there is now a code that applies to them. So, for example, if the speed limit on the road said, maybe we'd like it if you drove 60 miles an hour, but you don't have to, the chances are you'd speed in a way that you wouldn't if you knew the law applied to you. And so for that reason, the Supreme Court should do what it has occasionally said it wants to do, which is create its own code of conduct and then follow it.
Is there anything that prevents Congress from requiring the Supreme Court to establish or adopt a code of conduct?
Not at all. This Congress has the authority under the Constitution to require the Supreme Court to have a code of conduct and follow it. And that is consistent with decades, indeed centuries, of legislation by Congress regulating the judicial ethics of all Article III judges. To be clear, of course, Congress has no authority to interfere with the decisional independence of the court, and that is not what we're talking about. We're talking about ethics codes, and that is squarely within Congress's authority.
We've been hearing a lot about, on the full committee as well as on this committee, the influence of dark money on the selection of judges, particularly the amounts of money spent by the Federalist Society and their ilk. So I would recommend to all of our Republican colleagues that they vote for the Disclose Act, which will require disclosure of dark money donors. That is a clear indication of whether or not that the Republicans and their continuous concern, so-called concern about dark money influence, they can put their votes where their mouths are. For Mr. Payne, here in the Senate, we are bound by strict ethics rules, and it seems like the judicial branch is not subject, not it seems, it is. The judicial branch is not subject to such rigorous rules when it comes to the disclosure of gifts, travel, and income. Can you explain the major differences between the gifts and hospitality that can be accepted and must be disclosed by a member of Congress in contrast with what can be accepted and must be disclosed by Supreme Court justices?
Yes. So in Congress, the members can accept travel from privately sponsored, from private entities, but that travel has to be disclosed and it requires pre-approval. But with the court, they can accept this travel. There's no pre-approval, and the disclosure only happens at the end of the year, and that leaves the public in the dark with determining whether there are any potential conflicts of interest. And also, the personal hospitality exception is interpreted with the Supreme Court very broadly, as opposed to with the members of Congress.
So basically, without a very clear code of conduct, without a very clear requirements for recusal, without the requirement for disclosing of gifts and travel, et cetera, basically the Supreme Court is unto itself and it can do whatever it wants in this area. Isn't that right?
There is no check on their ethical decisions and no decisions to show that they are incorrect.
And as the Supreme Court continues to be faced with decisions that will impact all of our lives, i.e., overturning Roe v. Wade, I think it is stunning that they do not have a code of conduct and ethics provisions that applies to them. Thank you, Mr. Chairman.
Thank you very much, Senator Hirono. And for the record, Senator Hirono referenced the amount of money that has been spent in this effort to